All right. Hello, everybody. My name is Ryan Cordell, and welcome to the latest installment of the Hicks Thomas CLE series. This presentation is entitled Bienvenue in Louisiana, or Welcome to Louisiana. And my goal here today is to demystify the practice of law in Louisiana for Texas litigators. Along the way, we're going to look at a brief and highly abridged history, the civil law, and how it came to be in Louisiana. We're going to talk a little bit about what you need to practice in Louisiana as an out-of-state litigator. And we're also going to consider some high-level philosophical, procedural, and substantive differences between the laws in Louisiana and Texas. My goal for this presentation is that by the end of it, I hope you'll be convinced that the law in Louisiana and Texas is more similar than it is different, that you'll be primed with confidence to handle matters in Louisiana when the opportunity arises. A little bit about myself. My name is Ryan Cordell. I actually went to law school in Louisiana at Tulane University in New Orleans. At Tulane, there's a common law and a civil law track. I chose the common law track, but by osmosis and being around the civil law students, I did get a little bit of exposure to the civil law. So I had a little bit of base knowledge coming into this. But the real reason that I'm doing this presentation today is I had the wonderful opportunity to take the Louisiana bar exam this summer. I did pass. I'll be sworn in on Monday, but along the way, thank you for the applause, everybody. Along the way, I did leave myself some breadcrumbs, noting differences between Texas law and Louisiana law, things that I thought were interesting, completely different, that could be practically useful. It also served the other purpose of helping to keep me from getting confused between the Texas law and Louisiana law, I now know. So consider the following situation. Your client calls you and they've been sued in Louisiana State Court, and as your trusted advisor, they want you to handle it. A variety of questions may cross your mind. How do I find local counsel? Do I need to learn some French? Isn't the law completely different? To the last question, regarding the law being completely different, I'm here to assure you that it's more similar than it is different. But to get this started, let's start with a prompt where the law is different. So consider the following device, and I want you to read it and ask yourself if it's valid or invalid in Louisiana. I leave my 20-acre plot of land to my daughter Amy for her life, and after that, to my son Billy in perpetuity. So for my in-person audience here, does anybody have a guess whether this is valid or invalid in Louisiana? We got one valid from the room. That's not the right answer. So this is a valid device in the neighboring common law states such as Texas, Arkansas, and Mississippi. Doesn't violate the rule against perpetuities or any fun stuff like that. But this is not valid in Louisiana. Okay. In Louisiana, this is what is referred to as a prohibited substitution, as opposed to a vulgar substitution. So a prohibited substitution is when you charge a donee with property and ask them to preserve it until their death and then give it to someone else. Cannot do that in Louisiana. Prohibited substitution. A vulgar substitution, on the other hand, despite the name, which is kind of nasty, is perfectly legal. Here's an example. I leave my 10-acre plot of land to my daughter, Amy, and in the event that Amy does not accept it or is predeceased, to my son, Billy. So that is just an example of how some terminology may be confusing, how certain subjects of law can be a little bit different. So an example of where the law is different. So we'll get to the question I asked about local counsel, and we'll talk a little bit more about select areas where the law is different. And you may only need to know select bits of French. We'll cover some of that. But to understand Louisiana's legal scheme, it may be helpful to start with a little history. So massive disclaimer here, I am not a historian of the civil law. My intent is just to introduce some high watermarks and give you a little bit of background of where the civil law came from and how it ended up in Louisiana. So civil law has its earliest origins in ancient Rome. And of course, as the farther back you look in history, the murkier it becomes, but sort of the first high watermark in what is now the civil law is a publication called the Corpus Juris Civilis, which was enacted by Emperor Justinian I between 529 and 534 AD. It's sometimes referred to just as the Code of Justinian. This was during the time of the Eastern Roman Empire, also known as the Byzantine Empire, with its capital in Constantinople. So what happened with the Corpus Juris Civilis is that Justinian took power, and there was an absolute maze of prior imperial enactments, laws, customs. The people didn't know what was up or down. It was very confusing, and it led to a lot of congestion in the Roman court system. So he had his I guess fellow government employees or whatever pull together, consolidate, and kind of hash through all these pre-existing imperial enactments. And this is what they ended up with, the Corpus Juris Civilis. It's sort of like a restatement of Roman civil law as it was at the time. I'm not going to go too deep into the history, but from this high water mark, the Roman Catholic Church, other canonic law became a big influence. And so the law kind of evolved and changed over time. Eventually, though, it was rediscovered in northern Italy by some scholars in about 1070. That was sort of a reemergence of the civil law in Europe. From that point, the more contemporary roots lead us to Spain and France. The civil law evolved in Western Europe, most notably for the purposes of today in Spain and France. Along the way, it accumulated some differences, also retained some similarities, but in each country, it developed its own distinct flavor, so to speak. Another term you might see is the jus commune, which is basically the term for the modernized body of civil law that is shared amongst the Western European countries. So let's go from the old world to the new. Now we're in Louisiana, or what is now today the state of Louisiana. And let's talk a little bit about the colonial ownership of Louisiana. So from 1699 to 1762, it was owned by France, 63 to 1800, Spain, and then for a 3-year period at the beginning of 1800 to 1803, it was owned by France. For the reason for the switching back and forth is beyond the scope of this presentation. Imperial conquest, wars, treaties, countries trying to fill up their war coffers. But the important thing to note here is that the people that were living in what is now Louisiana at the time had been dealing with civil law in one form or the other for, give or take 100 years. So that's what they knew. In 1803, the United States, of course, bought Louisiana Purchase, which included what is now the state of Louisiana. And that is where William Claiborne enters the picture. So Mr. Claiborne was the first American governor of Louisiana, or the territory of Louisiana at the time. And so he takes over, and you can imagine the people who were living there were like, what's the deal? We just got, taken over by a new country. What's the law? So one of the first things Mr. Claiborne did was issue a proclamation. One of the parts of that proclamation was all laws and municipal regulations which were in existence at the session of the late government remain in force. So that gave some comfort to the people in Louisiana that, okay, we're still going to be dealing with civil law. It's what we're familiar with. However, Mr. Claiborne was a common law man. He was actually a former Supreme Court justice in Tennessee. He intended to convert Louisiana Territory into a common law jurisdiction. So when his intent to communize, so to speak, Louisiana became public, it aroused intense public opposition. The reason for that, as I've previously touched upon, was mostly cultural. Most Louisianans were of French descent, French Creoles. They were familiar with the French and Spanish law, and Louisiana's principal trading partners at that time, the colonies in the Caribbean, were all also governed by civil law traditions, whether Spanish or French. So that made a lot of sense, and from a commercial perspective, to be dealing on the same plane law-wise. So that was the state of discontent in Louisiana soon after Mr. Claiborne took over as governor. Enter James Brown and Louis Moreau Lisle. So these two gentlemen were prominent Louisiana lawyers, and in somewhat of a compromise by the Louisiana legislature for the territory, they were selected to basically codify all of the civil laws that were in effect at the territory at that time. The result is one of the foundational works of Louisiana law, which is called the Digest of Civil Laws now in force in the territory of Orleans. And it was formally adopted by the legislature on March 31st, 1808. And so that is where the civil tradition of Louisiana was firmly entrenched. At that time, the code was approximately 85% of French origin and 15% of Spanish origin. From there, the laws of Louisiana continually evolved and were revised several times over the next 200 years. Along the way, the law developed rules that are neither French nor Spanish in origin, but are simply original Louisiana creations. They were drawn from Anglo-American law, so the law of the surrounding common law states, the uniform laws of the United States, and civil law principles from other civil jurisdictions around the world. So after Mr. Brown and Mr. Moreau Lislet, the 200 intervening years, where are we now? Well, we have an interesting mix of traditions. I just went ahead and put this quote in here. I thought it summed it up very nicely. At its core, the private law, that's the law that's between private citizens, remains largely civilian. Civil law predominates in a number of subfields, including successions and property, but other subfields consist of a more or less equal blending of the rules of Anglo-American, common law, and civil law derivation. For example, security devices, partnerships, and delicts or torts. And many subfields are governed entirely by the law of Anglo-American derivation. For example, commercial paper and corporations. So the point is, there's a lot of common law in Louisiana, things that you're familiar with. Only in certain areas are there going to be distinctly civil law concepts. The two bodies of law have kind of synchronized and evolved closer together over the years. So let's go back to our hypothetical. Your client is sued in Louisiana. And so here's a few of the questions we're going to examine first. Do I need local counsel? The short answer to that is yes, you probably do, unless an exception applies, and we're going to talk about that. Can I appear PHB? Yes. Still, you have to have a local counsel. We'll talk about that. Do I need to learn any French? No, but we'll talk about some terms. It might be helpful. You know, if you can learn a little bit of Latin, I guess you can learn a little bit of French. So let's look at the local counsel question. Louisiana generally does not grant true reciprocity to lawyers from other states. They take pride in their civil law tradition. They expect you to know it. The questions on the bar exam are all about these intricacies of civil law. There's probably a little economic exclusion going on there, but they don't really grant reciprocity. Generally, you must have a local counsel, but there are some exceptions. One of them is if you're from a state that allows a Louisiana barred attorney to appear pro hoc vice in that state without associating with a local counsel. Louisiana will honor that. For those viewers who are in Texas, Texas is not one of those states. So if you are a Texas lawyer, you must have a local counsel if you wish to PHB in Louisiana. For those in-house counsel who may be listening, you also have an exception. You can apply for a 4-year limited renewable license if you are admitted in another state, and if you are exclusively employed in Louisiana by a corporation or other business whose activity is not practicing law. So if you're an in-house counsel, there's a readily available exception for you to operate for your Louisiana employer. Out-of-state attorneys can also conduct temporary non-appearance related legal services. There's a whole list of these, but I think the two most relevant and notable are you can conduct discovery in Louisiana without having to PHB or take the bar. And you can also conduct and participate in ADR in Louisiana. So discovery and ADR, you're good to go. If you have to make an appearance in court, generally you need to either take the bar exam or find local counsel and go through the PHB process. And then the last exception I want to talk about is you can render legal services in Louisiana if it's in anticipation of litigation that's going to be filed in Louisiana, and you reasonably believe that you will be permitted to PHB or pro hoc vice into the case once it's filed. So let's talk about pro hoc vice. Yes, you can practice in Louisiana on pro hoc vice admission, but as we talked about a little bit previously, you must associate with a local counsel. Now, the way you get admitted pro hoc vice is a little bit convoluted. So the important takeaway I want you to get from this is you need to get the ball rolling early. If you've got a matter in Louisiana, you need to get with your local counsel and you need to get this process started. You first have to apply to what is called the disciplinary board. That includes a $450 fee. It's got to be verified by the applicant and the local counsel they associate with. The disciplinary board then forwards that letter to the disciplinary counsel, who approves or disapproves the application and then sends a letter to the applicant. Once that happens, you get to file an ex parte motion and you must attach that letter. The motion cannot be filed within 30 days from trial. And then after it's filed, there's a 20-day objection period. So your opponent, if they're worried about you, has a chance to attack you and try to make it so you do not get admitted PHB. One of the most frequent objections is that you cannot engage in frequent appearances that constitute regular practice. So how much that is hard to say. It's a totality of the circumstances test, a case-by-case basis. There's not a lot of law on it. I have seen some cases where 20 appearances over a 1-year period was clearly way too much. But you'll have to use your discretion there. If you're practicing in federal court in Louisiana, it's everything you're already familiar with, the same old PHB requirements. But the point here is get the ball rolling early, get with your local counsel, and try to get through this convoluted PHB process. So you successfully navigate the PHB process and you get admitted, and you're able to work on that case in Louisiana. So now we're going to talk about some of the differences you might encounter while you're there. First and foremost is the judicial philosophy that judges use is a little bit different in common law jurisdictions and civil jurisdictions. So we'll talk about that. There are some intricacies in civil procedure and practice that might be interesting. It's largely the same, but we're going to go over some of the differences that might trip you up and that you need to be aware of. And then there's also some significant substantive differences in certain areas of law. Not all of them may be different, may be pertinent to your practice. Like I mentioned earlier, a lot of it is in family law, estates, property law, things like that. Your general commercial law is going to be governed by the UCC, things of that nature. Contracts, much the same, but we're going to run through all that. And then we're also going to go through a list of legal terminology you might encounter, and we'll talk about those Louisiana terms, what they mean, and more or less what their common law counterparts are. So first, judicial philosophy. As us common law lawyers know, the judiciary follows the principle of stare decisis, which essentially means they follow the precedent of court decisions before them. Civil law jurisdictions, on the other hand, have a slightly different jurisprudential philosophy, and that is jurisprudence constante. In essence, it means that previous decisions applying a particular legal principle or rule are highly persuasive, but not controlling. The judges are not bound to follow them. I have a couple quotes here you can read, but the takeaway from those is in Louisiana, judges have a more constrained role in interpretation compared to Texas. Their primary duty is to apply the written laws as clearly laid out in statutes and codes. Precedents, while still considered, have less binding authority in Louisiana than in common law states like Texas. It means previous judicial decisions are not as heavily relied upon when interpreting laws. Louisiana judges tend to focus more on analyzing the wording and intent of the statute in question. And their job is to use that statute, not merely rely on past decisions. So if you're finding yourself going into a Louisiana court, bring your case law with you. It'll be very persuasive, but don't expect a single case to carry the day. But it might. It's up to the judge. So your case starts, and one of the first issues you're thinking about is the statute of limitations. In Louisiana, that's referred to as prescription. You know, it's kind of an unfamiliar term. Some people may have run into it before. It's not what your doctor gives you. It's not what you get at Walgreens. It's basically the statute of limitations. So it refers to the expiration of a legal right or claim after a certain period of time has passed. Just like a statute of limitations, under certain circumstances, it can be interrupted, suspended, or renounced. And in Louisiana, the prescriptive period sometimes can be paused or even restarted. So prescription, basically the same thing as statute of limitations. Preemption. This is one I had a lot of time struggling with during my studies. It's sort of like prescription, but not really. It would be more equivalent to a common law statute of repose. So a preemptive period refers to the definitive and absolute extinguishment of a legal right after a specific period of time. Once that time period expires, the right itself is completely destroyed, not just your ability to assert it. Unlike prescription, preemption cannot be interrupted, suspended, or renounced. It's a very hard and fast rule. So once again, the equivalent there in common law jurisdictions would be a statute of repose. I'll tell you different causes of action in Louisiana. They'll either have a preemptive period or a prescriptive period. I couldn't make heads or tails of which or which, but when you're dealing with a particular cause of action, make sure you look at whether it's described as a prescriptive period or a preemptive period and act accordingly. So just for some examples of those causes of action, in Louisiana, prescriptive periods apply to personal injury claims, contractual disputes, tort claims, and debt collection schemes. So I would say most of the time you're going to be dealing with a prescriptive period. Preemptive periods apply in things like legal malpractice claims and challenges to certain legal instruments such as wills, powers of attorney, etc. So that gives you a little general landscape of when prescriptive versus preemptive periods are used. Prescriptive periods in Louisiana, as you may have noticed, can often be very different from what they are here in Texas. For example, torts, you can't use the handy moniker 2-year tort to describe most every tort. In Louisiana, it's 1 year. So you got a smaller fuse, faster deadline. You need to be aware of that when defending or asserting a claim in Louisiana. Breach of contract, on the other hand, much larger statute of limitations or prescriptive period, 10 years as opposed to 4 years in Texas. Although I will note that for certain oral contracts, the statute of limitations, or I should say prescriptive period, can be reduced in Louisiana. So for example, oral contracts such as related to wage claims, rent on lease of a movable, or open accounts can be less than 10 years, usually 5. So there are some differences in serving your pleading and then as well as the pleading itself, both making an affirmative pleading and responding to it. So in Louisiana, when you're trying to serve something, pretty much everything goes through the sheriff. The only time you can get a private process server is if you get a certification, more or less, from the sheriff that they could not affect service. At that point, you can get the court to authorize you to hire a private process server company. Texas, on the other hand, you can use any person authorized by law, which is a pretty broad definition. So keep that in mind when you're trying to figure out how to serve your lawsuit or attacking the way it was served upon you in Louisiana. As far as pleading goes, there are a little bit different pleading standards. Texas, of course, uses a fair notice pleading standard, which requires some factual detail, but you have a little bit more flexibility and room for amendments. In Louisiana, it's more of a fact pleading standard. So Louisiana is going to hold you to a more specific and detailed factual pleading. There's a little bit less room for vagueness or amendments without scrutiny. And sort of the same approach is reflected in responding to pleadings. In Texas, you got the good old general denial. It's Monday morning, something comes across your email and you got to get something on file. General denial, maybe a couple of affirmative defenses, you're good to go. Not so in Louisiana. Louisiana is much like federal court, actually. You have to respond to each particular factual allegation by admitting, denying, or stating that you lack sufficient information to admit or deny. So something to keep in mind, if a client comes to you with a case that needs an answer in Louisiana, you can't just slap a general denial on there and deal with it later. You're gonna have to drill down into the facts much quicker. Here's a little bit about deadlines. Here's one area where I find that Texas is stranger and more confusing than Louisiana. As we all know, you've got that first Monday after 20 days, 10 a.m. answer deadline in Texas. Never really quite understood why, but in Louisiana, it's a nice, easy 21 days. So there's a little bit less room for error when you do the math or have someone else do the math. So keep in mind 21-day answer deadline in Louisiana. And then the way that default in Louisiana works pretty much the same as it does in Texas. It's just called something different. Louisiana, it's called preliminary default, and in Texas, it's a default judgment. So you answer, or you're about to answer the case, and your local counsel may ask you, hey, do you want to make any exceptions? You might say, what? What's that? So these are what exceptions are. It's sort of a catch-all category for what in Texas would be either an affirmative defense or something you would put into a motion in response to a pleading before you actually file your answer. And there are three types of exceptions: declinatory, dilatory, and preemptive. So a declinatory exception is something that declines the jurisdiction of the court. Some illustrative grounds would be insufficiency of citation, insufficiency of service of process, improper venue, lack of personal jurisdiction, or lack of subject matter jurisdiction. A declinatory objection has to be filed with or prior to the answer. The next category is a dilatory exception, and that is an objection interposed to delay the proceeding. It's usually in the form of an objection to the form of the proceeding or for more information. Some of the grounds for that would be the want of an amicable demand. So, for example, if you have a suit on a sworn account and you don't send a demand for that prior, a dilatory exception would be something to assert. If there's vagueness or ambiguity in the petition, dilatory exception is the way to go. And then if there's a lack of a procedural capacity, that's another instance when you might use a dilatory exception. Peremptory or preemptive exceptions are something that results in the dismissal of the suit. So these are like things that would go in your traditional motion to dismiss in Texas. Some illustrative grounds would be that prescription has elapsed, that preemption has elapsed, that res judicata wipes out this claim, or even preclusion by judgment wipes out the claim. A peremptory judgment, unlike a declinatory or dilatory exception, does not need to be asserted necessarily in your answer or prior to it. It can be raised at any time before trial and even sua sponte by the court. Now let's talk a little bit about discovery. And there's not really too much to talk about. It should be very familiar. It's modeled pretty much after the federal rules. So you can proceed in discovery without being worried too much about the intricacies of it. There is one thing that stuck out to me, however, and that is interrogatories. In Texas, in the typical level 2 case, you get 25 interrogatories. In Louisiana, you get 10 extra. So don't forget about them, use them. You can send a little bit more out your first round of discovery. You don't have to reserve as many. So that's one thing to keep in mind when you are in discovery in Louisiana. So let's move on to some significant substantive differences between Louisiana and Texas law. Now, we're going to jump around a bit. Some of these areas may not apply to your practice necessarily, but I think they're interesting nonetheless. So a really big one that a lot of y'all may be familiar with is how mineral estates and oil and gas are treated in Louisiana versus Texas. So in Texas, as you may know, the acquisition of real property includes both the surface and the subsurface, including any oil and gas or minerals that are contained in the subsurface. Unless, of course, the mineral estate has been severed from the surface estate, in which case you end up with two separate and distinct estates occupying a single parcel of land. And because you can't have separate estates, you can't have separate owners. So you can have the owner of the surface and the owner of the subsurface. Louisiana is different. You can't separate the surface and subsurface rights. Under Louisiana law, minerals in place are not susceptible to ownership. So if they're in place, they cannot be owned. Thus, rather than owning the subsurface minerals, landowners in Louisiana own a right to produce the minerals, and they can convey that right to another through what is called a mineral servitude. All of this is governed by the Louisiana Mineral Code, and it's basically a right of enjoyment of the land belonging to another for the purpose of exploring for and producing minerals and reducing them to possession and ownership. So say you transfer a mineral servitude to someone else, and they now have the right to use and enjoy and extract those minerals. They better use it within 10 years because there's what's called a prescription of non-use. So if they don't start extracting those minerals and producing them within 10 years, the mineral servitude and the rights associated with it transfer back to the landowner, and you start where you began. And then in Louisiana, ownership, like I said, of minerals does not occur until the minerals are severed and reduced to possession. So that's a big one. A lot of people may run across. Here's an interesting concept. I just kind of like the words. Lesion beyond moiety. This is a remedy in Louisiana that does not exist in Texas. So the general idea here is that it's a remedy that a seller has when they sell a piece of land for less than half of what its value was at the time of the sale. So say you get a smoking hot deal on a piece of land in Louisiana, it's worth $1 million. They sell it to you for $200,000. You think, wow, I really got that guy. What a great deal. Not so. He can pull you into court, certain action for lesion beyond moiety, which basically means lesion beyond half, and assert this remedy against you. And he can either make you give back the land and exchange the purchase price, or you can also get damages to make up for the difference. So this is kind of just a funky little thing. You may never run into it, but it's there. Forced heirship. This is another interesting thing. So this is basically a protective measure that's in a lot of civil law jurisdictions. It's designed to ensure that certain family members receive a minimum share of a deceased person's estate, thereby safeguarding their financial interests. The system it's distinct from kind of the freedom of testation concept that exists in most common law states. Under the civil law jurisdictions, you'll find that protecting and prioritizing familial obligations often takes precedence over individual testamentary freedom. So if you think you can cut that little brat out of your will, think again. If they fall within the definition of a forced heir, subject to certain exceptions, they're going to get at least a fourth. So what is a forced heir? It must be either a first degree descendant, which is either 23 or younger when the decedent dies, or they're disabled. That means they're either currently physically or mentally incapable of taking care of their person or administering their estate, or they have an inherited incurable disease that also makes them incapable of those things. You can also have a forced heir by representation, which means if you have a descendant whose parent has predeceased you and they otherwise qualify as a forced heir, they can also be eligible for the legitime. Legitime is the term for the forced portion. If you've got one forced heir, it's 1/4 of the active mass of the estate. If you've got two or more forced heirs that meet that definition, they can get up to 1/2 of the active mass of the estate. which they split. So now, if you really wanted to cut that little brat out of the will, and turns out he's a forced heir, you may still have some options. If you validly disinherit him, he no longer qualifies for forced heirship. There's a couple ways that may happen, but if you can prove that he struck his parents, or if that he treated you with cruelty, attempted to kill you, or married someone as a minor without your consent, you can cut them out. And this one is my favorite. You can disinherit someone from a will and exempt them from forced heir status if after they reach the age of majority, they did not talk to their parents for 2 or more years, despite having the ability to do so. So keep that in mind. Non-competes. So this may be something that commercial litigators run up against. Louisiana has a very strong public policy against non-competes. They've got a statute that covers it. They're generally disfavored. They're strictly construed against the party seeking to enforce them. They're really only enforceable if they meet the statute. A non-compete must specify the exact parishes or municipalities where the restrictions apply. And it has to be exact. If there's any ambiguity, a non-compete will be thrown out. The maximum duration is 2 years from the termination of employment. And then you can't work your way around that with the choice of law. You can't say Texas law is going to apply to this. No. They're always going to apply the law of Louisiana to a non-compete agreement. Texas, it's more of a reasonable time and place restriction. So an employer can do a lot more in Texas and non-compete against a former employee. In Louisiana, it's much tougher. So let's look a little bit at some tort law. And between Louisiana and Texas, there are some differing comparative fault schemes. So Louisiana is a pure comparative fault system. That means even if a plaintiff is found to be 99% at fault, they get their 1% of whatever the damages amount is. Texas, as you may all know, is a modified comparative fault state. That plaintiff is more than 50% at fault, they take nothing. So big difference there as far as tort law goes. As far as liability of defendants, in Louisiana, defendants are generally joint. The liability for defendants is joint and divisible unless there is an intentional tort, in which case solidary liability will apply. And the equivalent of that is just joint and several liability. Any individual defendant can be liable up to the entire amount of the judgment. And then, of course, they can move for contribution, et cetera, from the other defendants later. Texas, generally several liability for the defendants unless the fault of any defendant is over 50%, in which case it is joint and several, or as they would say in Louisiana, solidary, or in Slido. Punitive damages. In Louisiana, there basically are no punitive damages. The whole scheme is set up to be compensatory, and there are very limited exceptions. Number 1, driving while intoxicated. Number 2, sexual abuse of a minor. Number 3, criminal child pornography. All deserve punitive damages. In addition, another important exception is Civil Code Article 3546, which says that punitive damages may be awarded if authorized by the law of the state where the injurious conduct occurred, and either the law of the state where the resulting injury occurred, or the law of the place where the person whose conduct caused the injury was domiciled. So in certain circumstances, if another state allows for punitive damages, you may be able to get them in Louisiana, but probably not. It's kind of a confusing code article, but there it is right there if you want to go look at it, 3546. So we're getting to what may be the more laborious portion of the presentation. And this is a little bit of thesaurus. So if you're going to be engaging in cross-border dealings in Louisiana, I highly recommend you consult a thesaurus to help you interpret any words you may encounter that you're not familiar with. If anybody wants to email me after this presentation, I'm happy to send you one that's publicly available that I thought was very good. It's a 1994 one, Civil Law to Common Law Dictionary. And you can also probably find it on LSU's website. But I want to walk through some terms generally categorized and kind of explain what their Texas equivalent would be. So in Louisiana, there's this concept of concursus, which is a legal proceeding where multiple parties with competing claims on the same funds or property are brought together to resolve those claims. What is that in Texas? You can see right there, interpleader. That's pretty straightforward, but Louisiana, concursus. In Louisiana, a reconventional demand is what you call a counterclaim. I probably don't need to explain what a counterclaim is, but Louisiana, reconventional demand. A declinatory exception, we've already discussed that a little bit. That's usually something that would go in a motion to dismiss, not based on the merits, or a motion to transfer venue. And then, of course, the Texas counterpart is plea to the jurisdiction or motion to transfer. Dilatory exception, we discussed that as well. It's interposed to delay the proceedings. That's a lot like a special exception. You know, we can't understand what the heck you're saying in your petition. You know, please replead before we have to respond. I didn't mention earlier, but declinatory exceptions and dilatory exceptions and peremptory exceptions, if you lodge them, you do not have to file an answer until 10 days after they are ruled upon. So it's a good way as a defendant to kick the can down the road is to file some exceptions. We talked about preliminary default versus default judgment. Same thing, different terms. We talked about prescriptive period and the statute of limitations, preemptive period and the statute of repose. There are some differences. Those definitions don't equate perfectly, but generally that's the closest Texas counterpart. Partition by licitation. It's the same thing as partition by sale. That is dividing co-owned property or property that is owned in division in Louisiana by selling it and dividing the proceeds among the co-owners. Tutorship, the equivalent to that is the guardianship of a minor. It's when a legal guardianship over a minor's person or property is appointed, and it's typically when one or both parents are deceased or incapacitated. Curatorship or interdiction are basically the same thing, but for adults. And then a suspensive appeal is pretty much just like a supersedious appeal in Texas. It's an appeal where you file a bond and it supersedes or suspends the enforcement of the judgment during the pendency of the appeal. Here are some property terms, and this is where things get really weird. Usus, fructus, and abusus. That's the use, the fruits, and abuse. Those are basically the bundle of rights that you get as a property owner. Usus is the right to use and enjoy property without altering its substance. Fructus is the right to collect fruits or benefits from properties such as rents or crops. That's a lot like the right to income, and usus is like the right to use. And abusus is basically the right to alienate. It's the right to dispose of or alienate property by selling, donating, or destroying it. And that's the third component there of usus, fructus, and abusus. A usufruct, someone who has the right of usus, is a person who has the right to use and enjoy another's property and its fruits or income without altering its substance. So they have the usus and fructus elements there. Usufructuary is that person who gets to enjoy the usufruct, similar to a life tenant. And I skipped over it, but a usufruct is basically a life estate. The flip side of a usufruct or a usufructuary is the naked owner of a property. So once the usufruct or life estate ends, they're the person that gets the interest. And common law jurisdictions, that's an estate and reversion, a remainderment, or a remainder interest. Movable and immovable property. Those roughly are equivalent to personal and real property. It makes sense. What doesn't make sense is the way that things are categorized as movable property or immovable property in Louisiana. There's a whole analysis that goes with it. I won't bore you with it. If you ever take Louisiana bar exam, you will spend a lot of time doing practice questions, trying to classify pipelines and pump stations, et cetera. You might think, oh yeah, those are immovable components. It's movable property. Not always the case. Even if it can actually physically be moved, It may be immovable. Even if you can't really move it, it might be movable. It's hard to tell, but they generally equate to personal and real property. Corporeal and incorporeal property, that's a lot like tangible and intangible property. That analysis is much more straightforward. And then both Louisiana and Texas are community property states. In Louisiana, it has a much more elegant name, the community of the Quets and Gaines. And Texas is just community property. Emphitosis. You may not run into this one, but I thought it was cool. It's a long-term ground lease, basically. So it gives the lessee the right to develop property, but they must return the property at the end of the lease. The servitude is basically an easement. It's a real right that grants one property a limited use on another person's property. Right of use is like a license. It's a personal servitude that allows a person to use the property of another for a limited purpose, but not to the full extent of a full-blown servitude. Acquisitive prescription, not to be confused with a prescriptive period. That's adverse possession. So it works a lot like it does under Texas law. You need to have a continuous, uninterrupted use of the property that's adverse, et cetera, et cetera. But in Louisiana, it's acquisitive prescription. And then arpent. This one's really cool, and I've never seen this one before. Evidently, it's only really used in rural parishes, but it is 0.85 acres. So if you ever run across that word or it comes up at a random trivia night, there you go. 0.85 acres is an arpent. Contractual terms. Instead of promisor and promisee, you have the obligor and the obligee. Pretty straightforward. Cause. This is a lot like consideration in contractual law in Texas, but cause is more broadly defined. It's not limited to the exchange of something of value, like consideration would be. It's simply the reason why a party enters into a contract. So if you have a dispute about cause in a contractual setting in Louisiana, you need to slow down and pay attention to the law surrounding that. Don't just take it as face value that it's the same thing as consideration. Error is basically the equivalent of mistake. It's a way to void the contract if it relates to a party's consent for entering that contract. Suspensive and resolutory conditions are conditions precedent and conditions subsequent. Pretty straightforward. A stipulation pour autri, I may have butchered that, but that's a third-party beneficiary contract. I'm guessing pour autri means for a third party. A natural obligation, that's an interesting thing of Louisiana law. You can have a natural obligation that's not inherently enforceable. But if you make a promise on top of it, for example, if I owe you $100, but the statute of limitation has run and there's nothing you can do about it, you're not getting your $100 back. If I later say, you know, I realize I owe you that $100, all of a sudden that natural obligation becomes enforceable. So that's an interesting thing. An absolute nullity is something that is void. A relative nullity is something that is voidable. Vices of consent. Those are basically the doctrines of lack of capacity, fraud, duress, or undue influence, which can make a contract void or voidable under certain circumstances. A simulation is when the parties create a contract that's not intended to have real legal effects, but is instead intended to deceive others. That's a sham transaction or a fraudulent conveyance in Texas. And then a solidary obligation, we touched on this earlier, is solidary liability. It's joint and several liability. All of the obligors are liable in solido. I've been informed we have about 5 minutes left. This is my last slide on terms. Mandate as an agent, ownership and division are joint owners or joint tenants. And I'll kind of let you go through the rest. I really like synallagmatic contract. That's a reciprocal or bilateral contract. A pacte de preference, that's the right of first refusal. Delicts or torts, a testament's a will. A décharge in payment is a deed in lieu of foreclosure. And instead of a mortgage, you have a hypothec. So all sorts of funky terms. I hope this underscores my point. Get a thesaurus before you go across the Sabine. So in conclusion, we covered a little bit of history, and it's Louisiana's unique history yielding unique laws. But, as you can tell by the things I covered today, that they're all mostly out there. Most of the main law you're going to be dealing with is similar to the common law of Texas. So civil law and common law are more similar than they are different. You got to find a local counsel. Even if you're going to PHBN, I advise you to have a dictionary. And I hope you all go forth and practice with confidence. So with that, I'll leave up the CLE number and I'll open up the floor for any questions and answers.
So Ron, I've got two questions. First off, you had mentioned prescription. Do they have a discovery rule in Louisiana?
Yes, there is a form of the discovery rule that under certain circumstances can pause or interrupt prescriptive periods.
And also, I know you've got a lot of experience with premises liability and personal injury cases. Did you note anything, the differences between substance of those laws between Texas and Louisiana?
I did not, but I would be happy to look into that and get back to you. But I can't answer the
What
question.
about the workers' comp bar?
Workers' comp, I can't answer that. In Louisiana, it's really hard to opt out of workers' comp. There's very limited exceptions. Pretty much every employer in Louisiana has to be enrolled in workers' comp. The schemes are a little bit different as far as the ways they calculate a average weekly wage, et cetera. But the main difference is that in Louisiana, most employers, I think 30 or more employees, have to be enrolled in workers' comp. I've got the chat.
What has your experience been in Louisiana so far, and has taken the bar make you want to have more or less?
Well, now that I've taken it, I expect that or hope I will have some work over there. Otherwise, it'll be for naught. I have had some experience practicing in federal court in the Western District of Louisiana, involving some Louisiana law claims, I got some exposure to this. For example, the want of amicable demand in a suit to collect on a sworn account was an issue I had to deal with. Prescriptive periods was an issue I had to deal with. And then we were a little surprised to have 35 interrogatories sent our way. Well, actually, no, it was federal procedural law, so that didn't happen. But I have had a little bit of experience.
Can I ask a question about
Yes,
the lease? At least I've understood the mineral and land are not severed, as understood in Louisiana. And if you give the right for someone to explore, it's limited to 10 years. Does that mean an oil and gas lease is limited to 10 years, or how is that structured, or how is that enforced? Do you have a feel for that?
I don't know if you can contract your way out of the prescription for non-use. It's sort of like my understanding is it's sort of like a lease where you make an agreement where they have to start drilling or move towards drilling within a certain time period. Otherwise, it reverts. So under that hypothetical, I think an oil and gas company, if they're making activities, drilling wells, I think that keeps the mineral servitude open.
Did you start where you were exploring?
Right.
I got you.
I think so.
Very nice job.
Thank you.
Follow up to his question is,
Yes, sir.
can the lease go on in perpetuity if they do continue to develop the oil and gas?
I do not know the answer to that question. I would imagine there might be a legal limit on that somewhere in Louisiana law, but on the other hand, could be a contractual freedom to contract issue. I don't know.
Some outer limit that comes to mind after looking at all of the stuff at the bar.
Not that I'm familiar with at this time.
Texas right would be controlled by production. And if there's production, I don't know if there's
Right.
an analog over there, but.
What's appellate procedure over there like? Do they have a courts of appeal and Supreme Court like us?
They do. I didn't look too deeply into that for this. My understanding is they have the same general appellate structure. The way they're organized, I think there's 5 appellate districts, and the deadlines are a little bit different than they are in Texas. So if you ever have a matter on appeal, make sure you pay close attention to that.
Do you have a number of colleagues that you work with over there in terms of a starting roster of local counsel, or are you learning that also?
I do. I am familiar with some lawyers out in Lafayette that have been excellent local counsel on cases I'm familiar with, and I'm happy to share those with anybody who wants to email me. In fact, my contact information is at the beginning of the presentation. But contact the firm. I'll be happy to share and recommend any local counsel.
And has your experience been that they're comfortable going to most parishes, or is it a situation like a few places in Texas where you need local counsel and then it's someone plugged in?
My experience has been limited to Lafayette. And we were in federal court, and even there, it did seem that, you want to have the lawyer that has the good relationship with the judge. So I would imagine I have heard in more rural jurisdictions, that relationship is even more important. So,
Some things are similar in the common law.
right, it's very similar to common law jurisdictions. With that, I believe it's about 1 o'clock. I don't see any questions in the chat, but please feel free to reach out. You can find my email on the Hicks Thomas website. If you miss a CLE number, let me know and we'll get it to you. But otherwise, thank you for attending this presentation. I hope you enjoyed it.